Welcome to Environmental Law course, dear learner and viewer. After having delivered 3 lectures on the various aspects of the Environment Protection Act 1986, the one considered to be the genesis and object, ambit and scope, and the power of the rule-making power under the Environment Protection Act by implementation and enforcement, these 3 lectures will pave the way to understand how Environment Protection Act 1986 happens to be an umbrella legislation. Dear learner and viewer, we have already taken note of the genesis and the object, and then we saw that its sweeping ambit and scope, and then implementation and enforcement. Now we are going to undertake the Environment Protection Act 1986 examination, as it has been popularly termed as an overarching and having assumed a notion of umbrella legislation. How the introduction and overview of the Environment Protection Act through its definition and concept and salient features have created an image, an aura about the notion of umbrella legislation, and how we will see that the net effect of the section 6, which regulate the environmental pollution in India, happens to create a kind of a power and delegation of duty, and that delegable duty on the central government have created a kind of a bulwark to make a plethora of the environmental rule, and the environmental rule making exercise giving effect to the standards of the environment have resulted into a galloping jurisprudence of delegated legislation, wherein in section 6 we have noted that the central government may by notification in the official gazette can make rule in respect of any or all the matters referred to in section 3, and in particular and without prejudice to the generality of the foregoing provision, the section try to envisage that such rule may provide for all or any of the following, namely that the standard of the quality of the air, water and environment, and it will try to establish the maximum permissible and allowable limits of concentration of various environmental pollutant, including the noise pollution. Thus, what we see under the section 6, that the first is air, another is water, and then it has added the question of the noise pollution, although we do not have any kind of a parent law, and the entire noise pollution control mechanism in this country is governed by under the rule 6 by the noise pollution prevention and control notification of 2000. With this sweeping range and the overreach of the section 6 of environmental rule making power, the central government is enjoined upon to create an elaborate mechanism for the handling, regulation, storage, import, export, and transportation of the hazardous substances, and it also tries to see that the entire locational map, so that we must have a very viable and effective planning for controlling the industrial accident arising out of and affecting the common and innocent people in the vicinity of the industry. So it also try to see that how the location and the industrial mapping and industrial zoning is to be created, and that zone atlas are to be identified, so that the environmental pollution and its harmful effect should not reach to the common people, and it should be contained in a very effective manner. It also try to create rules and regulation for prevention and control of the industrial accident, and suggesting some kind of a remedial measure. We have seen that how section 5, which confers the power of direction, and it create an automatic directorate besides Central Pollution Control Board and a State Pollution Control Board. The Environment Protection Act creates a directorate, and that directorate is reflected under section 5, wherein the central government has power to give direction which cut short the entire procedural wrangle of bringing defaulting industry or the erring industry or the negligent industry to the task and to the terms of the Environment Protection Act. This section 5 of directorate and directive, which has been issued into this law as a novel addition has created a concurrent amendment into the Water and Air Act by Section 3 and Section 31A by an amendment into these two acts. Now, as of now, we see that the Pollution Control Board are not struggling very hard to bring to the compliance and avoid the deviances of the environmental law, water law, air law without charting the route of the litigation and going to the court, but it has conferred a direct power. Thus, we see that both the authority, instead of the directorate power which has been conferred and the delegation of the duties to Central and Pollution Control Board under Section 20, have authorized to enforce the stricter compliance of the standards of the Environment Protection Act. Now, we see after that the Section 6 and Section 5 taken together, it has expanded rule-making enforcement regime and establishes an overarching legislative framework, and that is the subject of our inquiry, that how the Environment Protection Act 1986 can really be said to be an umbrella legislation, as an overarching legislation encompassing the broad range of the environmental pollution, conservation and abatement of and prevention of industrial accident. Thus, we see this overarching legislative framework is made possible by Section 5 by its directives and Section 6 by its rule-making power, and combined together a reading of these two enactments, what we feel that the notion of umbrella legislation regarding the Environment Protection Act holds ground, and because it entrusts central government with expansive authority as it has been contained under Section 3.1 and 3.2 and 3.3, and then taken together a study of Section 2, 3 and Section 4, which talks about the kinds of authorities which have been created, and the authorities list is something a very long and elaborate list, and that list needs to be needs and deserves to have a kind of a look and just see that the authorities which has been created or recognized under the Environment Protection Act is a kind of the authorities. This is the table which is in compliance of Section 4 of the Environment Protection Act, that we see that besides creating a directorate of and on the Section 5 and the Central Pollution Control Board and a State Pollution Control Board, what we find that there is a plethora of the agencies, and each and every agency deserves to be studied. The first and foremost happens to be that under the Factories Act is the one aspect that authorities has been created or recognized. The second aspect is the authority which has been created under the Energy Act, then Atomic Energy Act, and then we see that these two authorities like Atomic Energy Act, Factories Act, and then the power which is vested to the Ministry of Environment and Forest and Atomic Energy Regulatory Board, inspectors of the factories. Other than then we see that besides the factories, and Atomic Energy Factories Act 1941 is one aspect, Atomic Energy Act is a second aspect, and the third aspect what we see, mines and mineral regulation and Mineral Development Act 1947 is the another authority which is being recognized under Section 4. And if we go on perusing the entire list, then we find we have the Indian Ports Act as number 4, and then we have a Plantation Labor Act of 1951, and then we see that these acts have created a long range of authority, and then Motor Vehicles Act 1939, and it has been recently amended in 2018, and then Merchant Shipping Act is there. So what we see that the source happens to be the Rule 12 of the Schedule 5th of the Environmental Protection Rule have supplemented what has been said by Section 4. And if you look at the Section 4, the Section 4 simply talks about that Environment Protection Act, while implementing its provision for the protection and improvement of environment, have made elaborate a scheme of giving power of by appointment of the officers, and have conferred the powers and function in order to protect and improve the environment and control and abate the pollution. So what range is coming out of these environmental rule making power in Section 4 is not only the Central Pollution Control Board, not only a State Pollution Control Board, but a series of inspectorate and commissionerate and a cluster of authorities, as we have seen in the chart which has been appended to the Rule 12 of the Environment Protection Rule, and it serves as a ready reckoner to see the entire mechanism of the Environment Protection Act, be that the Factories Act, be that the Atomic Energy Act, be, be that the Mines and Mineral Regulation and Mines Regulation and Mineral Development Act, be that Indian Port Act, be that Plantation Labor Act, be that Motor Vehicle Act, be that Merchant Shipping Act, then we have to see that how Section 4 is being supplemented by the Rule 12, and by envisaging a large number of authorities to come in unison and to come in, in rescue and help, and then it tries to work in tandem with the object of controlling the pollution and as well as protecting the environment in this country. With this, what we see that the notion of umbrella legislation also have its bearing with Section 4 and Rule 12 of Environment Protection Rule, Schedule 5th, that needs to be taken in a very holistic manner to understand that the notion of umbrella legislation, which permeates from Section 4, permeates from Section 3, Section 4 and Section 5, and ultimately the Section 6, which confers a wide and sweeping power for the rule making, thus creates a kind of an expansive role, and the notion of umbrella legislation, the environment protection, can really be said to boast upon. Now, the notion of umbrella legislation is also being adduced and corroborated, not only the sequencing of section 3 and 6, but we also see that the two rules which has been framed, the one rule we have just given the example of the Rule 12 of the Environment Protection Rule, Schedule 5th, which supplement section 4 of the Environment Protection Act. Likewise, there is a series of supplementary and complementary rule which tries to set the norm, and that supplementary and complementary rule making power is very important in assuming and a notion and impression about the umbrella legislation, environment, be that environment protection rule, that needs to be a careful perusal, and we see that whatever details and whatever the inputs and whatever the, the elaboration of the authorities and standards are required, that has been put forth and carried out in the Environment Protection Rule 1986. Vis-a-vis, what remains important is the question of environmental siting and siting for industrial project rule of 1999. As we have said in the beginning, that in this lecture, that environmental rule making have focused not only the handling of the hazardous substances and creating a kind of a safeguard and the procedures about the hazardous substances, hazardous processes, but it also try to put restrictions and try to prohibit the entire spectrum of the hazardous activities. And what is more important, that it tries to have a locational policy, it has an industrial zoning policy, it has an industrial atlas to be and it has a kind of a mapping policy, and that mapping policy is being supplemented by industrial siting environment siting of industrial project rule 1999, and which is very important to give effect that the cases of industrial accident which generally happens because of the poor and haphazard planning and location of the industry. Most of the industries are situated into the residential areas, and which a densely population can be minimized by this rule of environment siting for industrial project rule 1999. Besides these two rules are just the tip of the iceberg. We have a large numbers of rules and the numerous notifications which have been issued covering the industrial, ecological and pollution related aspect, and that rule to be seen under this concept of what we can say that the category like eco-mark scheme, which has been laid down by recognition of environmental laboratories and analysis in 1987, and the eco-mark scheme 1991, and criteria for eco-labeling of the cosmetic has been laid down in 1992. Then the notion of umbrella, notion of the Environment Protection Act can be verified and can be authenticated by its broad range of the categories of the notification dealing with the environmental pollution. In matters of waste management, we have a battery management rule, we have a municipal solid waste rule, we have recycled plastic rule, we have hazardous rule and biomedical rule. So the waste management is the another category which have received the attention of the legislature, and especially the delegated legislation and subordinate legislature to have to frame a detailed rule under the environment on the strength of section 6 of the Environment Protection Act and section 3 of the Environment Protection Act to indulge into a detailed rule making exercise. And this exercise is not only confined to here, but in matters of hazardous substances, in matters of noise pollution, in matters of ozone layer depletion, then we see that there is large numbers of rules. And as we have perused that the eco-mark scheme, as we have perused the rule making power under section 6, assuming the role of an overarching legislation in the context of battery waste, municipal solid waste, recycled waste, hazardous waste, biomedical waste, then hazardous waste happens to be one of the most, because the waste management in India are twofold. The one have hazardous waste, another is a different kind of the waste, which is battery, municipal waste, biomedical waste, plastic waste, and then this deserves a separate study. That's why we see that elaborate rule making in the context of the hazardous waste is the manufacture, storage, import of hazardous chemical rule 1989, chemical accident rule, genetically engineered organism rule, which is very important and which have genetically engineered approval committee of the uh, of the Ministry of Environment and Forest. And then we see that how the entire question of the hazardous waste after enactment of the Basel Convention on Transboundary Movement of the Hazardous Waste 1989, the India has been very quick and very active in giving effect under its rule-making power and the broad mandate which is enjoyed under section 3 of the Environment Protection Act to offer the slew of the hazardous waste notification. And then the question of the noise pollution, which have not received the attention of the legislature, although in the chapter or in the statute or the Environment Protection Act we have a detailed rule regarding the noise control in residential area, industrial area, institutional area and silence zone, the fourth categorization of the noise we have witnessed in the spectrum of the Environment Protection Act. So environment protection as a canopy and overarching and overwhelming legislation was not was not oblivious of the fact of the noise pollution, but while creating institutional, residential, and industrial, and as well as the silence zone has set the basic parameters of the noise control, but that parameter was not considered enough. And again, in the sweeping power of the section 3 and section 6 of the Environment Protection Act, it has framed noise pollution rule 2000, amended in 2002, 2003, and the control of noise pollution through the mechanism of the Environment Protection Amendment Rule has been put in the statute book in matters of secular noises, religious noises, firecrackers, or all kinds of activity. And this law has come heavily against all the communities which try to have noise in electioneering campaign, noise in the religious congregation, and then it sets the entire jurisprudence of right to life and personal liberty, right to sleep, right to trade and business and profession, right to religion. All kinds of aspects are being covered by the judicial indoctrination and paving the way for the noise pollution control rule in 2000. And thereafter, there are four series of the judgment by the Supreme Court in reference to noise pollution case 1, in reference to noise pollution case 2, in reference to noise pollution case 3, in reference to noise pollution case 4 in the year of 2006 is a milestone in deepening the understanding of the noise pollution, because we do not have a parent enactment as we have a parent enactment on water law and air law, environment law. We do not have a parent act, but as a matter of the delegated legislation and rule making power under section 6 of the Environment Protection Act, noise protection rule has been amended and put into a statute book. And lastly, we see the range of the key notification for environmental pollution control is what has been decided in United Nations Framework Convention on Climate Change, what has been decided into Kyoto Protocol, what has been decided into the Paris Agreement, then 2015, 2007, then taking recourse to all these commitment of United Nations Framework Convention on Climate Change and the Kyoto Protocol, and we see that India has been the forerunner in creating ozone depleting substances regulation and control rules 2000. Thus, dear learner and viewer, what point we are making here is to see that how Environment Protection Act moving to an umbrella legislation, and examples are galore, and we have tried to enumerate besides environment protection rule and environment citing for industrial rule, we have already taken note of a panoramic perception of the key notification concerning concerning section 6 of the Environment Protection Act, which ranges from eco-mark, eco-labeling to waste management, to hazardous waste, to noise pollution and ozone layer. On the other hand, the notion of umbrella legislation can also be gauged from the fact that what it talks about the coastal resource zone right from 1990, the pronouncement of S. Jagannath versus Union of India, there has been a greater movement to control the coastal regulation zone, which has been marked by the industrial as well as the residential habitat, and then how this coastal regulation zone have been an effective mechanism in protecting the coastal and marine environmental resources by Constitution of Coastal Zone Management Authority in 1998. It also talks about eco-sensitive zone, because in India being a very diverse country having a different climatic conditions, then what we see is the fact that the eco-sensitive zone may be, and the range of the eco-sensitive zone is Mahabaleshwar Panchagani 2001, and then Pachmali 1998, Aravali range Eco-Sensitive Zone, Doon Valley Eco-Sensitive Zone, and Dhanu Taluka Environment Protection Authority 1996 and 2001, and Mathran in 2003. Then it created out of the coastal protection of the coastal regulation and the coastal zone and the marine environment, and applying not only the environment protection law, but it also applied in case of coastal regulation zone, the international law relating to United Nations Convention on Law of Sea of 1981, and then it tried to see that to what extent the coastal zone are to be used in matters of the environmental and indiscriminate dumping and spoiling of the sea water, the coastal water is being taken care of by National Coastal Zone Management Authority, whereas economic eco-sensitive zone which have been denuded and has been encroached upon, then we required a separate set of the law, and this law has given rise to protection of a large Murad Janjira eco-sensitive zone in Assam, Bokakhat in Assam, then in across all geographical spread of the India, we had eco-sensitive zone protection notification time to time in the context of Valo Citizen Forum versus Union of India, the case decided by Justice Kuldeep Singh, and where the polluter pays principles were engrafted and applied, then in order to mitigate the land reclamation in the Nalore and Vellore district, the Supreme Court has constituted actually mean that what polluter pays principles require, that it has instituted an inquiry, and amicus query was appointed to look at the entire scenario of the loss and the damages which is being complained by the people. So much so, it also led to loss of ecology prevention and compensation notification in 1996 in the backdrop of Vellore case decided by the Supreme Court of India. On the aspect of environment impact assessment, although we had a notification in 1992 when the Brad Morse Committee report of the World Bank came into 1992 in relation to Narmada Bachao Andolan case, then after the Bradford Morse Committee report known as the World Bank Committee report is dealing with the Narmada aspect, then then we see that whatever suggestion has been crept into the Brad Morse Committee report in regard to the rehabilitation and resettlement of the people in Gujarat, in Maharashtra, in Madhya Pradesh and Rajasthan, in the light of that, we have witnessed environment impact assessment notification right from 1992, 1994, 1997, and then what has been made in 1992, 1994, 1997, the public hearing notification. All these EIA laws were ultimately being consolidated under the environment impact notification of 2006, and the EIA report and environment management plan 2006 has standardized the environment impact assessment as a tool of sustainable development. Here it remains to be said that the entire environment impact assessment law, which has been a late entrant only by the international pressure and the NGOs and the Narmada Bachao Andolan, and whatever laws has been passed in 1990s saw its culminating point in 2006, and EI notification 2006 happens to be very comprehensive notification and law on the point, and it remains to be said that 2006 is very important in giving effect and creating the notion or propagating the notion of umbrella legislation of the Environment Protection Act, simply because of fact that the Forest Commission report 2006 and environment policy uh, National Environment Policy 2006 and EIA notification 2006 are considered to be a breakthrough into the question of environment protection and sustainable development in 2006 in India. Thus, we see that the notion of the umbrella legislation which emerged out of Section 3, Section 4, Section 5, Section 6, then the entire approach can be said to be an springboard board approach, which at one hand resulted into a standard setting and creating a norm for the uh, emission of various kind of the pollutant. It also witnessed an industry specific environmental rules, and as we have seen the industry specific, that eco labeling, environment friendly product, and uh, eco mark scheme, and the laws relating to the waste management, laws relating to the hazardous waste, laws relating to the ozone depleting substances, notification, and rule regarding the noise pollution control. And then we see that industry specific environmental rule have been framed, and so much so it also has gone one step further in recognizing the ecological protection and the sustainable directives and imperatives of sustainable development by passing and amending and creating the rule making power for the coastal zone resources in India, CRZ notification, right from 1992 down to this day, that this regulation has been put forth with subsequent amendment and re-amendment, and try to encompass and try to improve the sea and as well as the coastal environment and the marine environment in country. It also given adequate attention to all geographical spread of eco-sensitive zone. What exactly number one, number two, number three is the ecological protection of environmentally vulnerable area and the fragile area, that vulnerability and the fragility of the environmental zones are being addressed, and we see that a large number of notification has been evolved and passed under this category, and the law relating to environment impact assessment also gave a great fillip to environment protection and as well as the sustainability directives. Thus, we see that the rank and files of the delegated legislation which emerged on the strength of Section 3, Section 4, Section 5, Section 6 of the Environment Protection Act have proliferated the entire discourse of the rule making and delegated legislation and legislative activism of the subordinate legislature to give an overarching framework of the environment protection, and giving this and buttressing and impressing upon the very notion of the umbrella legislation by encompassing all areas of environment protection and improvement as it has been suggested under Article 48A and the preamble of the Environment Protection Act has been achieved. Thus, dear learner and viewer, under this lecture, what we try to see that from a very critical perspective, that Environment Protection Act 1986 is really an umbrella legislation, that misgivings and confusion and the clarity that we wanted to propel upon and we wanted to propagate upon, and ultimately we think that Environment Protection Act, consisting of the 4 chapters and 26 sections, serves as a model law, serves as an umbrella legislation, some as a skeleton legislation, and ultimately the powers and functions which have been given under this act, and on the strength of that act, that the ranks and file of delegated legislation and an extensive and elaborate rule making power, and putting forth large numbers of rules and regulations for the protection and improvement of environmental quality and for the prevention and control of environment pollution has been set in this country. With this, I thank and I wish you a happy learning.